Welcome back to the deep dive. You bring us the dense, expert-level source material, and we cut right through the noise to give you the precise knowledge and insight you need. Today, we are undertaking what I can only describe as a masterclass in legal architecture. We're diving deep into the intricate world of Hanafi jurisprudence on marital dissolution, specifically the Kitāb al-Ṭalāq, or the Book of Divorce.
It's truly remarkable source material. I mean, what's immediately clear is that the Hanafi school treats divorce al-Aqwas. Well, it's not a mere administrative act, not at all.
No, it's treated as an act of profound legal and, I would say, moral consequence.
Exactly. It's almost like an architectural challenge, and it's governed by these minute details of language, the timing of the act, and the exact legal capacity of the person who's pronouncing it.
Absolutely. And the stack of sources we have treats this topic with. It's just a staggering precision. We're talking about rules where the difference between two Arabic prepositions can determine if a marriage ends today or, say, upon the husband's death. It's a huge amount of detail that, frankly, can feel overwhelming.
And that's really our mission today, isn't it? To distill this legal precision. We want to understand how the Hanafi jurists balance this need for legal finality with the core objectives of Sharia.
Which are what, primarily?
Primarily minimizing harm, prioritizing reconciliation wherever possible, and ensuring justice for everyone involved. So we'll explore what makes a divorce valid, who actually has the legal capacity to pronounce it, and how things as subtle as an unconscious gesture or an ambiguous choice of words can determine the legal reality of a marriage's end.
It seems like the ultimate goal, the thread running through all of this, is restraint. The law is actively looking for ways to slow down or even negate what is an irreversible decision.
That's a perfect way to put it.
So let's unpack this. We can start by setting the stage with the ideal path versus the sinful one. Let's jump into section 1. The categories of divorce sunnah versus sin.
Right. So when a husband decides separation is necessary, the Hanafi school provides a very clear moral and legal roadmap. It classifies the act of divorce into 3 distinct categories, and it's all based on timing and repetition.
Okay, let's start with the absolute gold standard. Al-Ahsan, which translates to the best. In such a high-stakes emotional act, what makes this form the most excellent?
Al-Ahsan sets the highest possible benchmark for restraint. It requires the husband to issue just a single pronouncement of divorce.
Just one.
Just one. And it has to be during a state of purity. There's also a time when the wife isn't menstruating, and crucially, a time when no marital intimacy has occurred.
Okay, so one pronouncement, very specific timing. What happens next?
After that single pronouncement, the husband must then, well, he has to physically and emotionally leave his wife entirely alone until her waiting period, the iddah, is fully completed.
That feels counterintuitive.
Yeah.
Why is complete enforced separation after just one statement considered the best form?
Because, as our sources really emphasize, this process is, and I'm quoting here, farthest from regret, least harmful to the woman, and safest.
Farthest from regret.
I like that. It is. By issuing only one divorce and forcing the husband to wait the full iddah, he still has the right to return the raja without needing a new contract. If the full 3 cycles pass, then the separation becomes final. But this restraint, it just maximizes the cooling off period. It maximizes the chance for a genuine voluntary reconciliation before the whole thing becomes irreversible.
So it weaponizes time against rashness. It builds in a break.
A very powerful one. This single act with the maximal waiting time was what was preferred by the companions of the Prophet.
Okay, so if that's the gold standard, the next category is Al-Ahsan, or the good. This is also known as the standard sunnah form.
Al-Ahsan is the standard procedure for a consummated marriage. Here, the husband issues 3 separate pronouncements of divorce, but they're over 3 separate successive periods of purity. So 1 divorce in each year.
A gradual, multi-stage dissolution.
Exactly.
So why does the law even permit repetition here if the single divorce Al-Ahsan is the most praised? What's the juristic rationale that allows this gradual increase towards finality?
The legal reasoning connects divorce to a recurring human need. Divorce is legislated according to need. And since desire, or, the need for separation, can recur during these periods of purity, the time legally sanctioned for the pronouncement repetition, up to 3, is permitted. It's aligned with that recurring need.
So it's a safety mechanism.
It is. The Prophet's guidance supported this gradual 3-stage approach. It ensures that the finality of that 3rd divorce isn't just an emotional outburst, but a decision that's been reinforced over a significant period of time.
Now, I did notice our sources flagged a really interesting scholarly difference here. Imam Malik viewed this three-stage divorce as, well, as excessive. He saw it as bordering on innovative, only allowing one. Why the difference in perspective?
Imam Malik grounded his position in the restrictive nature of the law itself. He argued that the original ruling for divorce is prohibition, or if. That makes it legally restricted.
So one is all you need.
In his view, yes. Only one divorce is necessary and sufficient to fulfill the human need for separation. Anything further, he argued, potentially contradicts the principle of delaying that final break.
But the Hanafi saw it differently.
They did. The Hanafi school placed greater weight on the reported practice of the Prophet and his companions, which established this three-part repetition as permissible within the scope of necessity.
Okay, that gives us the ideal path, al-Wasan, and the standard path, al-Lasan. Now, the third category is the most problematic one, al-Bid, the innovative or forbidden divorce. What makes this so legally sinful?
This is the critical breach of those principles of restraint we've been talking about. Al-Badi occurs when the husband rushes finality.
How so?
Either by pronouncing 3 divorces in one single statement, saying, for instance, you are triply divorced, or by issuing 3 separate pronouncements, but all within a single period of purity.
He's just getting it over with.
He's rushing it, and the consequence here is vital. The law confirms the divorce occurs. It achieves that final, immediate separation, but the man incurs sin.
Wait, so there's a disconnect. Why confirm the validity of a sinful act? If it's forbidden, why does it still count?
This is a powerful demonstration of the law balancing legal validity and moral rectitude. The pronouncement itself, issued by a capable person using explicit language, it fulfills the legal conditions for ilaq.
So the boxes are checked.
Legally, yes. Therefore, the legal effect takes place. The marriage is over. However, because the method contradicts the fundamental principle of restraint and gradual dissolution legislated by the Sunnah, the husband is held morally accountable. He's accountable for disregarding the safer, more restrained path.
So the law grants validity to protect the certainty of the marriage status, but it imposes a moral censure on the transgressor.
Precisely. It's a mechanism that punishes the reckless behavior without denying the legal effect of the words that were spoken.
Okay, let's pivot slightly to a timing issue that introduces a lot of complexity. Divorce and menstruating women.
Right. The rule here is very precise. A divorce pronounced during menstruation does take effect.
Even though it's prohibited.
Even though it's prohibited. This is because the prohibition against divorcing a menstruating woman is related to the harm caused by the timing, not the validity of the husband's utterance itself.
What's the specific harm?
The harm of unnecessarily lengthening her iddah, her waiting period.
So if the timing causes harm, the law must have a way to mandate a correction. What's that rectification mechanism?
By the strongest Hanafi view, it is mandatory, obligatory, or wajib, for the husband to immediately take her back.
He has to perform Raja.
Immediately to remove that harm. The famous prophetic tradition involving Ibn Umar confirms this legal reality. The divorce took effect, but the Prophet commanded immediate rectification by return. He told the husband to hold her until she became pure, then menstruated, then became pure again, and then he could choose to divorce her.
So it forces him to reset the clock to the proper time.
Exactly. It ensures the iddah starts at the proper time, preserving the wife's rights and the legal structure. It is the ultimate legal damage control. The law steps in not to nullify the act, but to correct its improper timing.
This all leads to a preference within the Hanafi school, then, to pronounce the divorce toward the end of the period of purity.
Yes, a very specific focus on the end of the air cycle.
And why is that?
It's really just a measure of prudence. If the divorce is issued at the beginning of purity, the husband has to avoid intercourse for that whole duration, which can be difficult.
Okay.
If it's issued right at the end, he has less time before the next menstrual cycle begins. It just reduces the risk of accidental intercourse and ensures the iddah starts promptly without being unnecessarily elongated.
So it minimizes ambiguity and the possibility of further sin.
Precisely.
Okay, so we've established the ideal timing and the rules governing when the act is permissible. Now we need to move to the person performing the act. And this is where it gets really, really analytical. Let's transition from the rules of execution to the legal framework of agency and choice. Divorce is a legal disposition, and for that to be valid, it requires sound capacity.
Right. This section analyzes capacity, or aql, and choice, ikhtiyar. For a legal disposition as serious as divorce to be valid, it has to be pronounced by an adult, sane person who is legally responsible.
So let's establish the clear boundaries first. Who is fundamentally excluded from this? What makes a divorce invalid?
A minor, an insane person, or a sleeping person. They are strictly excluded. The core reason is a lack of discerning intellect and/or choice. There's a legal principle from tradition that states the pen of accountability is lifted from these three.
The minor lacks maturity.
The insane person lacks reason, and the sleeping person lacks conscious volition, or ikhtiar. Their words just have no legal effect in this context.
That makes perfect sense. But the law gets far more complex when that capacity is temporarily impaired, specifically under coercion or intoxication. This brings us to two of the most hotly debated rulings. Let's tackle coerced divorce al-Mukra first. The Hanafi position is definitive. The divorce does occur.
It does, and this ruling is a hallmark of Hanafi jurisprudence. It contrasts sharply with the Shafi'i, Maliki, and Hanbali schools, which generally say divorce under coercion is invalid because, free will is absent.
Okay, hold on. If the man is coerced, maybe threatened with death or a severe beating, isn't he fundamentally lacking choice? He doesn't want the divorce. How on earth do the Hanafi jurists justify saying the divorce is valid?
This hinges on a very sophisticated legal definition of choice. The coerced person is placed in a binary situation, death or divorce.
Right.
They chose the divorce. It's the lesser of two evils, but they chose it to avert the greater harm. This establishes a legal act of intention and preference, even if the result was highly displeasing.
So the jurists aren't looking for free will in a moral sense. They're looking for the execution of a choice, however constrained it might be.
Exactly. The law isn't looking for satisfaction or happiness with the outcome, but the conscious, if unwilling, preference for one legal action devours over a physical consequence, like death. It focuses on the liability created by the utterance.
That's fascinating.
Our sources compare this directly to divorce made in jest or Hazel. The speaker didn't actually want the divorce, but the legal consequence still applies because the words were willfully spoken to achieve some objective, even if that objective was just to get the coercer to stop.
So it prevents the exploitation of duress to nullify otherwise serious legal actions.
It does. It's a profound application of legal theory, holding people accountable for the legal effect of their words, even when they're spoken under duress.
And this ties directly into the next contentious ruling, intoxicated divorce. The Hanafi position, again, is that the divorce does occur.
Yes. And this ruling is built on the principle of moral deterrence and accountability. If the intoxication occurred through a sinful act like the unlawful consumption of alcohol, legal accountability remains.
So the law sees the act of getting intoxicated as the original sin.
It does, and the subsequent loss of intellect can't be used as an escape mechanism from the legal consequences of being in that state. So if you engage in illegal conduct, you forfeit the right to use the resulting incapacity as a defense. It's a legal penalty layered right on top of the moral violation.
But there's a key distinction here, right?
A crucial one. We have to contrast this sharply, as our sources do, with cases of non-sinful incapacity. If the loss of intellect is due to, say, a high fever or necessary medication or unconsciousness,
things outside of your control.
Right. The person isn't morally responsible for their incapacity. In those instances, a divorce would not occur because that element of moral culpability is completely absent. The distinction between self-inflicted, sinful incapacity and accidental or medical incapacity is the hinge upon which the entire ruling turns.
We've been talking about the spoken word, but what about someone who is incapable of speech? How does the law handle the mute person and the rule of gesture, or ishara?
Since a legal disposition requires communication, divorce by a customary gesture, ishara, is fully valid in the Hanafi school. The gesture acts as a recognized, legally valid substitute for speech. It fulfills the need to convey the execution of that legal right.
And can that gesture convey numerical precision? If a mute person uses a gesture, can they issue a triple final divorce?
Yes, provided the gesture is customary and unambiguous. For instance, pointing clearly with 3 fingers can customarily indicate 3 divorces. This would lead to a final separation if that's the understood meaning within their community or by their own established method of communication. The law requires the exact same level of precision and clarity from the gesture that it demands from the spoken word.
That requirement for clarity is a perfect segue. We've established who can speak. Now, we have to dive into the language itself because the slightest nuance can change the outcome completely.
And this section is really a masterclass in linguistic analysis applied to law. In Hanafi jurisprudence, divorce is a matter of linguistic classification and customary usage just as much as it is a matter of intent. The specific structure of the phrasing determines the outcome.
Okay, let's start with the fundamental dichotomy. Explicit versus implicit kinaya wording. If I use an explicit statement like, you are divorced, what makes that distinct from any other phrasing?
Explicit wording, or gura, is defined by the fact that the term is conventionally used only for divorce. Because the meaning is so unambiguous, the statement requires no intention, no niyyah for the divorce to take effect. If someone explicitly says you are divorced, even if they later claim they were thinking of something else, the divorce occurs.
The words themselves have the power. And what's the legal effect of that?
It results in a revocable divorce, al-Ṭalāq, and this is the law's built-in restraint mechanism. Even if the speaker explicitly says you are permanently divorced, or even if they intend 3 divorces in their heart, the law defaults that explicit statement to revocable.
Wait. Why does the law override my clear intention for finality in an explicit phrase? That seems odd.
This is the genius of the Hanafi legal restraint. The law is designed to delay final separation wherever it possibly can. So explicit wording is taken at its minimum legal consequence, which is 1 revocable divorce. This allows for a return during the iddah. The law is actively preventing the expediting of finality. It's adhering to the principle of maximizing the chances for reconciliation.
Okay, so that's explicit. Now contrast this with implicit wording, or kinaya.
Right. These are phrases not exclusively used for divorce. Things like, you are a divorcee, or go join your family, or you are free from me.
These phrases must require intention then, because they could mean anything from just a dismissal to actual severance.
Exactly. They require intention niyyah to take effect. If the intention exists, a divorce occurs. But here is the crucial limitation that leads to this incredible legal symmetry. Only 1 divorce occurs, even if the husband intended 3.
That seems like an equally powerful legal break. Why does implicit language resist a numerical increase, even when the intention is clear?
The Hanafi school argues that these implicit terms, like describing the woman as a mutalaqa, are fundamentally a description of her status or a form of dismissal. It's not the direct act of divorce itself.
I see.
And since a description doesn't inherently vary in number, the language itself prevents the numerical intention from having any legal effect. So the law restricts the outcome to the minimum legal consequence possible, which is 1 final, or ben, divorce. It prevents a rash triple severance through ambiguous terms.
So explicit language is limited to revocable status to delay finality, and implicit language is limited to 1 total divorce, because the phrasing itself resists numerical counting. That is incredible symmetry.
It is. Now let's explore attribution and indivisibility. Divorce must be attributed to the entire person or a phrase that legally represents the whole.
Like saying your neck is divorced. That sounds very strange to a modern ear.
It does, but it is legally effective. This is derived by analogy from the Quranic usage, where neck signifies the whole person, as in the obligation to free a slave's neck. So the phrase, your neck is divorced, signifies the entire marital subject and results in divorce.
But if you try to attribute it to a specific limb, like your hand is divorced, that doesn't work.
Correct. The divorce does not occur. The marital bond is a contract over the entire person, and it can't be localized to a single limb. The law requires totality in the attribution.
And the rule of indivisibility is key here too. If I say half a divorce or a third of a divorce, what happens then?
The result is 1 full divorce. Divorce is legally indivisible. You can't legally execute a fraction of a divorce. The action is binary. It either happens or it doesn't. Since the intent was to perform the act, the minimum legal reality is 1 full, complete divorce.
This brings us to the part that genuinely makes a legal scholar appreciate the precision here. Complex numerical and range expressions. We need to walk the listener through the analysis of this.
Absolutely. The jurists had to account for every single permutation. So take the statement we mentioned earlier, 3 halves of 2 divorces.
Okay, that sounds like a math problem from a nightmare. Walk me through the legal arithmetic. How do we get to a ruling of 3 divorces from that?
The Hanafi methodology first parses the expression. The phrase 2 divorces is the verbal noun, the masdar, and it acts as the object of the divorce.
Okay.
We then apply the preceding multiplier, 3 halves. Mathematically, 3 over 2 times 2 equals 3. Since 3 is the maximum number of divorces a free woman can receive, the statement results in the maximum final separation.
So the law treats the utterance as a statement of multiplication and takes the result literally right up to the maximum legal limit.
Precisely. If the result were 4, it would still default to 3, because 3 is the absolute cap on legal dissolution. This shows the law's commitment to linguistic fidelity, but combined with practical legal limits.
What about ranges? This seems like a perfect place for ambiguity. If a man says, I give you from 1 to 2 divorces, what's the ruling?
Abu Hanifa ruled this results in only one divorce. His restrictive reasoning was based on common speech usage. Ranges often imply what lies between, and since divorce is such a weighty, restrictive matter, the law just leans towards the minimum effective number. If you say from 1 to 2, you are only definitively committing to the lower bound.
That's fascinating because it prioritizes restraint over ambiguity. But you mentioned his 2 companions, Imam Abu Yusuf and Imam Muhammad. They disagreed.
They did. They argued that the phrase includes the upper bound, so it would result in 2 divorces. They felt that mentioning 2 implies the speaker intended the maximum possibility within that range. This particular point really highlights how different jurists can interpret the same linguistic construction, but always against the backdrop of the restrictive nature of the law.
The ultimate linguistic tripwire, as I called it earlier, has to be conditional statements. This is where the legal concept of suspension really comes into play.
Let's look at a key Hanafi ruling. A man says to a woman he's not yet married to, "If I marry you, then you are divorced." This utterance is made before the contract even exists.
Logically, no divorce should occur. There's a hadith that says, no divorce before marriage. But the Hanafi ruling is that the divorce takes effect immediately after the marriage is contracted. How do they overcome that clear hadith?
The Hanafi interpretation argues that the hadith only negates immediate execution. The statement itself isn't an immediate execution of divorce. It's a binding oath or disposition, a suspension of divorce, that creates a liability on the speaker's legal capacity.
I see.
That liability activates the moment the marriage is met, and he has ownership, so to speak, of the woman. It's treated as a promise that becomes legally binding upon the acquisition of the contractual right.
So the oath creates a ticking legal clock that starts the moment the man obtains the authority to divorce her.
Exactly. It shows the incredible legal weight given to even premarital statements. Now, let's dive into the conditional negation using prepositions. This is where it gets very technical. Help us contrast the outcomes based on 2 subtle differences. So compare, you are divorced so long as I do not divorce you, using the phrase malam.
Okay, malam denotes a time constraint, right?
Yeah.
Like for the duration that I do not do X.
Correct. Ma and mata relate to time. This utterance means that the divorce is suspended as long as that temporal condition his non-divorce holds. When the husband remains silent for a prolonged period, indicating the expiration of that temporal constraint, for instance, if he dies without having divorced her, the divorce occurs. It's sometimes construed as having occurred immediately prior to his death. The focus is on the passage of the specified time.
Okay, so now contrast that with, you are divorced if I do not divorce you, using an lam.
Right. Inia is a pure conditional particle. It's not necessarily a temporal one. The condition, his failure to divorce her, is not definitively confirmed until despair of life or death. Since the non-occurrence of the condition is the trigger, the divorce occurs only upon his death, assuming he never performed the act. The preposition alone determines whether the divorce relates to the passage of time or the certainty of the condition's failure.
The legal gravity of linguistic choice is just. It's staggering. Finally, we have to discuss the crucial exception, what you call the ultimate legal undo button. It's this not the exception. The phrase, you are divorced if Allah wills, al-Ṭalāq.
If that specific phrase is uttered immediately and connected to the pronouncement, no divorce occurs at all. It functions as a legal suspension, negating the divorce from the outset. It's based on the principle that the act is ultimately dependent on divine will.
But I understand the timing is absolutely everything here.
It is paramount. The connection, the itial, must be immediate. If the speaker pauses or coughs or even takes a breath that isn't directly part of the linguistic flow and then says, if Allah wills, the first statement takes effect. The later phrase is then deemed an invalid retraction, not a legal suspension. The law demands immediacy to recognize that suspension of the speaker's own will.
We've established the rigid rules of language. Now let's shift to scenarios where the wife gains agency, either through a delegation of authority or through specific oaths and payments.
Yes. In this section, we move away from the husband's unilateral execution into shared authority and separations based on specific regulated agreements or oaths.
Okay, let's start with delegation of choice, or al-Ṭalāq. If a husband tells his wife, choose yourself or divorce yourself, her right to act on that is strictly limited to the same sitting, the Maslis. Why is physical location and immediate response so legally definitive?
The Hanafi school views this delegation as a form of contractual agency.
Like a business deal.
Almost, yes. Like the acceptance of a sale or a gift. The acceptance of the authority to divorce oneself has to happen within the presence or context in which the delegation was made. Standing up, leaving the room, engaging in a different, distracting activity, it immediately voids the authority. Physical departure signifies disengagement, and therefore the power just lapses.
So if she hesitates or gets distracted, the opportunity is lost forever, unless he chooses to delegate the authority again.
Correct. The law imposes very strict boundaries on the temporary transfer of this power. Now, if she successfully chooses herself in response to his command, the outcome is clear. One irrevocable divorce, adiyapanin.
Why irrevocable? We just spent a whole section establishing that explicit divorce often defaults to revocable to delay finality. Why does her choosing herself lead immediately to an irrevocable separation?
This is a ruling based on istiasan juristic preference, which is supported by early practice. The preference is that since the woman chose release, establishing exclusive authority over herself, the outcome has to be banin or final.
Because if it weren't,
If it were revocable, the husband could just immediately take her back, which would effectively nullify her choice. That would defeat the entire purpose of the delegation. The irrevocability protects her choice.
that makes perfect sense. The law ensures her agency is actually meaningful, and again, only one divorce occurs, even if the husband intended 3 when he delegated it.
Yes. The delegated act is one of choice, or ikhtiar, which, much like implicit wording, doesn't inherently vary in number. So the numerical intention of the delegator is resisted by the nature of the delegated act itself.
Next, we move to ilah, the oath of abstinence. This is where a husband swears by Allah not to approach his wife for 4 months. What is the legal outcome if he succeeds in keeping that oath?
If he maintains complete abstinence for the full 4 months, a final banned divorce occurs automatically upon the expiration of the term.
Automatically, without a single word being spoken by either party.
Yes. The oath itself sets the legal clock ticking. The rationale is that denying intimacy for this prescribed period constitutes oppression or of the wife's rights. The law steps in to compensate her for that harm and neglect by automatically ending the marriage after the term expires. It ensures that she's not just left in a state of indefinite marital limbo.
And what if he breaks the oath and resumes intimacy during that 4-month period?
Then he breaks his oath, or haneth, and he owes expiation, kafara. He avoids the divorce, but he incurs a religious penalty for breaking his solemn vow. It just reinforces the gravity of oaths in marital relations.
Okay, moving to cool divorce by redemption. This is a powerful avenue for the wife to initiate separation, usually because she fears they can't fulfill their religious obligations together.
In Kul, the wife offers money or property or maybe relinquishes her dower in exchange for separation. The result is an automatically final bond divorce, and she is legally obliged to pay whatever was agreed upon.
Our sources noted a really fascinating nuance about the compensation itself. What if the compensation she offers is something legally unlawful, like alcohol, khamr, or pork?
This is where the law protects the integrity of the transaction. The divorce still occurs because the purpose, the mutual separation, has been achieved. However, the husband receives none of the invalid compensation.
So he gets nothing for it.
Nothing from the unlawful part. If the wife offered a house and a bottle of wine, the divorce occurs, she owes him the house, but the wine is legally invalid. This ensures the transaction is untainted by unlawful substances while still achieving the separation.
That separation of legal effect from material consequence is incredibly precise. Finally, dihar spousal prohibition, saying, "You are to me like my mother's back."
This is a pre-Islamic custom that was highly condemned. The law transformed it from what was a statement of final divorce into a temporary prohibition. The wife becomes prohibited for intimacy, no intercourse, no desire-filled touching, until the husband performs a very severe expiation, kafara, which is prescribed in the Quran.
And what does that required kafara hierarchy look like? It's famously strict.
It is. It's performed in a mandatory, strict sequence. The husband must first attempt to 1. Free a slave. If he can't, he must move to 2. Fasting for 2 consecutive months. If he cannot manage the fasting, only then may he perform. 3. Feeding 60 poor people.
And all in that order.
All 3 steps must be attempted in order, and the expiation must be completed before intimacy is resumed. It's a mechanism designed to be so difficult that it acts as a severe deterrent against using such offensive and harmful language toward one's spouse.
This entire section really illustrates how the law provides multiple, highly regulated exits from a marriage, ensuring accountability whether it's through oaths and financial agreements or severe penalties.
And now we move to the final phase, the legal consequences that define the space between a marriage and a complete separation. We have to address duration, the possibility of return, and financial stability.
Right. Once divorce is pronounced, the legal focus shifts entirely to managing that transition phase. This is defined by two mechanisms: Raj, or revocable return, and aitana, the waiting period.
Let's start with Raja, revocable return. If a woman is divorced once or twice revocably, the husband retains the right to reconcile during the Ida, and this right is, well, it's generally absolute, regardless of the wife's consent.
Why is that?
It's because in a revocable divorce, a Raji divorce, the marital possession remains legally intact. The husband is just temporarily restricted from intimacy. So since he still holds that marital right, the Quranic instruction to hold them with kindness permits him to reclaim her unilaterally.
What acts actually constitute a valid raja? Is it only a clear verbal statement, like "I take you back"?
While a verbal statement is the clearest method, the Hanafi position is unique because it also includes certain physical acts that indicate the continuation of the marriage contract by desire.
Like what?
Things like sexual intercourse, kissing, or touching with desire, even looking at our private parts with desire.
Wait a second. So if a husband, during the Ida period of a revocable divorce, simply kisses his wife with desire, the marriage is automatically reactivated, even if he didn't say a single word.
Yes. The physical act, coupled with desire, demonstrates his intention to hold the marriage, and it triggers the legal revival of the contract. This really underscores the profound legal weight given to intimacy in marital relations. It also provides a clear mechanism for the marriage to continue without requiring a formal verbal notification, though verbal declaration and calling witnesses are very highly recommended for a precaution.
That makes the continuation of the marriage an active physical state, not just a verbal formality. Okay, next. Al-Ayuda, the waiting period. What are its dual purposes?
The primary purpose is, without question, the confirmation of the purity of the womb. This ensures lineage clarity, or nasab. The secondary purpose is to allow for the necessary legal and emotional transition before any remarriage is permitted.
Let's delineate the key durations, as they depend entirely on the woman's biological state.
For menstruating women, it is 3 full menstrual cycles. For non-menstruating women, whether due to age or a medical condition, the duration is 3 lunar months. The month substitutes for the cycles to establish clarity.
And for pregnant women?
For pregnant women, whether they are divorced or widowed, the term ends immediately upon childbirth. Finally, for a non-pregnant widow, the Ida is 4 months and 10 days. The law adapts the duration precisely to the biological reality of the woman, and it's all to safeguard lineage above everything else.
Now let's talk about financial safety. Maintenance, nafaka, and housing, sukna. Maintenance is generally obligatory for the wife, regardless of her own wealth, correct?
Correct. It includes food, clothing, and housing, and it is considered a debt, a dain, upon the husband. It's enforceable through the courts. This obligation is linked directly to the husband's responsibility to provide for the wife in return for her confinement to the marital bond.
And there's a requirement for a specific type of housing.
Yes, the husband must provide a private dwelling, a dar mufrada. That's a secure place where no other family member resides unless the wife consents otherwise. It's to ensure her privacy and her security.
How do those financial rights shift after a divorce is pronounced?
The entitlements are determined by the status of the divorce. The wife is entitled to full maintenance and housing during her Ida for 2 key reasons. 1, following a revocable divorce because the marital possession is still legally retained. And 2, following an irrevocable divorce if she is pregnant. That's based on a clear Quranic mandate to provide for her until she gives birth.
And major exception.
If she is irrevocably divorced and not pregnant, she is not entitled to maintenance during her Ida. The marriage contract is completely terminated and no marital right remains, although housing is sometimes still granted out of prudence.
Finally, let's discuss custody, aqul walad, and movement. When children are involved, the law establishes a clear priority.
Maternal priority is paramount. The mother is considered most entitled to custody because of her inherent affection and capability, a wisdom that was recognized by the Prophet.
But that right is contingent.
It is. She loses custody if she remarries, as her loyalty and her time would naturally shift to the new marital bond.
What are the age limits for her custody before the father's right supersedes hers?
The mother generally retains custody of a male child until he reaches the age of independence, around 7 years old, when he can independently feed and dress himself. She retains custody of a female child until menstruation, which is intended to ensure the child understands female etiquette and preservation during early adolescence.
And what about the physical restriction on the mother's movement? She can't just move across the country and fundamentally change the father's access to his child.
That's one of the key points that balances parental rights. A divorced mother cannot take the child outside the current domicile unless it is to her original home where the marriage contract was established. The law prohibits movement that would cause undue harm or loss of oversight for the father, prioritizing the child's stable environment and the father's rights to visitation and instruction.
Okay, we have covered a lot. The categories of dissolution, the required legal capacity, the dissection of linguistic expressions, the regulated pathways of delegation and redemption, and the whole architecture of post-divorce responsibilities.
What really stands out, looking back on all this, is the sheer depth of consideration given to human failing. The law builds these restraints against emotional rashness, whether it's the mandatory return after a divorce during menstruation or the severe expiation required after the sin of dahar. The system demands the maximum level of restraint possible at every turn.
For me, it's the linguistic precision that remains so striking. The law recognizes the binding legal effect of a word spoken, even if the speaker was coerced or intoxicated. Yet at the same time, it overrides the speaker's clear intention if it contradicts the law's objective of delaying finality, like defaulting explicit phrases to revocable status.
And what's fascinating here is how consistency is maintained through it all, whether it's the rigid structure of the IDA ensuring lineage clarity or the technical analysis of which preposition activates a conditional statement. The rulings always prioritize certainty and the balance of responsibility. They ensure that justice and restraint prevail, even when the relationship itself has collapsed.
We saw how saying 3/2 of 2 divorces results in 3 because the law respects the mathematical totality of the words, but saying you are al-Ṭalāq results in only 1 because the language itself resists the counting. The law treats language as a physical binding material.
Indeed, it forces us to recognize the gravity of every single utterance.
So here's something for you to mull over. If the law dedicates this level of intense, granular focus on conditional prepositions, the if, the so long as, the unless, because they determine the future legal reality of a relationship's ending, how carefully should we be crafting the conditional statements we make when we are starting a commitment, not ending one? Think about the conditions and assumptions you build into your everyday relationships. Are they as clear and as legally binding as an inlam or a malam?
A provocative thought to end on. We'll be back next time for another deep dive.
Thanks for listening.